BA Cityflyer Ltd against Mr. Kenneth Lipton and Mrs. Linda Lipton.
May it please your lordships and your ladyships, I appear for the appellant with Mr. Damjanovic. The respondent is represented by Mr. Rawlinson, King's Counsel, and Mr. Archer and Mr. Eisenberg, and the intervener is represented by Mr. Dehaan, King's Counsel, and Mr. Coley.
Yes.
Lord, what I propose to do is to deal very briefly with some of the facts and procedural history, not very long, then move to Regulation 261 itself and its context, then address Ground 1 and then Ground 2. I propose to spend about an hour, 25 minutes on Ground 1 and 45 minutes on Ground 2.
Ground 2 being the accrued law point.
Being the accrued law.
We might be assisted if you were to address them the other way around.
My Lord, I can do that. Obviously, I prepared it the other way around, but I can look at Ground 2 first and then come to Ground 1.
Thank you.
And you'll have seen that we have agreed between the parties an allocation of time.
Yes. Thank you.
My Lord, as you know, and my ladies, as you know, the key issue in this appeal is whether the cancellation of a flight because of a sudden and unexpected illness of the captain whilst off duty for reasons not related to his work engages the defence of extraordinary circumstances. And the case was decided at first instance and on the first appeal before exit day. The Court of Appeal then heard the appeal after the implementation completion date, i.e. after the transition period. And the question which the Court of Appeal took was to apply retained law. That obviously has some differences from the EU 261 Convention.
When you say they applied retained law, you mean the regulation as amended by the 2019.
That's correct. There were two.
That's what you're referring to.
That's what I'm referring to. There were two options of retained law. There was either the EU Regulation 261 as it existed, that was automatically transferred in its unamended form, or in the alternative, at the same time as the legislation was passed in the UK, bringing the EU regulation into UK law, there was an amendment made, and that was the amended passenger regulations.
But the unamended version only existed for a scintilla.
Exactly.
Yes.
So it is. I believe that certainly the Court of Appeal proceeded on the basis it was the amended.
Yes, but your submission seemed to be saying that there were two. I think you said there are two versions of retained law: the unamended regulation translated into domestic law, and then the amended version.
Yes, I think that there were. I think that, but that, as my Lord Lloyd Jones said, there was a scintilla of a moment, because logically, the original one has to come in before you can amend it. My Lord, Ground 2 then involves two questions really. The first is which version of the regulation should be applied to the facts of this case, and the second, what are the principles of interpretation to be applied to that regulation. And in particular, which, if any, of the European Union decisions is this court bound by? And as I just said rather inelegantly a moment ago, that question arises because of the chronology of the procedural history of this case. As your lordships will be aware, on the implementation completion date, IPCD, as has been abbreviated, EU Regulation 261 ceased to have direct effect in domestic law, and a domestic Regulation 261 was incorporated into domestic law under Section 3 of the European Union Withdrawal Act, and I'm going to call that the 2018 Act, and also was immediately amended by the Air Passenger Rights and Travel Organisers Licensing Amendment Regulations, the APR regulations, and you see those in tab 1 of the authorities bundle. And the domestic regulation was known as a form of retained EU law, but from the 1st of January of 2024 is referred to as assimilated law. And as we discussed a moment ago, therefore there are...
Sorry, when you say assimilated law, that's the later piece of legislation,
That's correct.
2003, that
we don't have to
force, I think, very, very recently.
Indeed, it did. 1st of January 2024.
Yeah, have we got a reference to that, please? Electronic reference to the latest legislation.
So we have certainly the APR in authorities one. I don't believe we have. Actually, we do have the latest legislation, which is in the authorities bundle tab 2.
Can we just have the electronic reference, if possible, please?
432.
Thank you very much.
So 432 is the amended regulation, and then 4297 is the actual European Union Withdrawal 2018 Act in its most current iteration. And then in the supplemental...
The difficulty with that is that the version that's in the bundle is as amended by the 2023 Act.
Yes, so that we have also included added the original, or the one that was before the Court of Appeal, which would have also been the one in place at the start of January 2021.
You mean, which would be the Withdrawal Act as amended by the Withdrawal Agreement Act?
That's correct, and that is in the supplemental authorities bundle. I'm afraid that would be a freestanding bundle at page 2.
Let's just look at that. So, at page 2, this is the version.
This would have been the version that was in force at the Court of Appeal hearing and also on IPCD.
When you say page 2, do you mean item 2?
Version.
No, this is the supplementary authorities.
I'm looking at it.
Oh, okay.
It's page 120, isn't it?
Sorry, which page in that bundle, the supplementary bundle, are you inviting us to look at?
It starts at page 2.
My page 2 just it says European Union Withdrawal Act 2018, Chapter 16, Preamble.
Yes, that's the start.
What you want us to look
that's the start of it.
So,
and that would be the version in force, as I said, at the IPCD date and also the Court of Appeal hearing.
so this is the version of the primary legislation in force.
As at IPCD and the Court of Appeal, the current iteration, as at today's date, is actually in the authorities bundle at starts at page 297.
I'm sorry, it's completely my fault. I'm a little bit confused. So the document I'm looking at in the supplementary authorities is a version of the European Union Withdrawal Act.
Correct.
Yes.
Right. And that is different from that. This is the version in law in force at the moment.
No, this is the version that would have been in force at the start of January 2021, and also when the Court of Appeal hearing was heard in March of 2021.
So is this as amended by the Withdrawal Agreement Act, but not as amended by the 2023 Act?
Correct.
So here we have Section 4, whereas in the version in the main bundle, Section 4 doesn't exist because it was repealed in 2023.
That's correct.
Okay, thank you.
And Section 4 is obviously important in this in the analysis of how you transfer into UK law various rights. So, my Lord, and my ladies, the Court of Appeal, as you've seen, and it's the judgment of Lord Justice Green at paragraphs 72 and 82, treated the version of the amended regulation as applying. In other words, the one that was amended on implementation day. And that has subsequently been followed, at least at first instance, in a case called Verano versus Air Canada, and that's in the authorities bundle at page 1052. And if I could just turn up one of the issues that has identified in that case, is that there were subtle changes between the EU Regulation 261 and the amended regulation. And so one sees that the case begins at 1042, but the relevant passage and the bit I just want to show you is at page 1052.
In the main bundle.
And it's just paragraph 72 of that judgment, which is the effect of the analysis set out by Lord Justice Green in Lipton is potentially far-reaching. Leaving aside the wider potential implications, I note that the amended regulation is limited in scope to passengers departing from an airport located in the UK,
yes,
etc. And therefore it's conceivable that a claim that might have been available under EU Regulation 261 would not be available under the amended regulation just because of the jurisdictional threshold of where it applies. So that's one of the differences that's illustrated by this judgment if it were to apply.
At some point, I hope someone might be able to explain, for my benefit, why, if the respondents are right and the amended regulation applies, why it applies to a flight from Naples.
This is a flight from Milan.
From Milan, sorry.
Yes, well, I think the answer to that, my lord, is that it's a British carrier, a UK carrier, right, and therefore it bites on a UK carrier.
Right.
But it's also a flight to the United Kingdom. So that would be the threshold under the amended regulation. Right. But I can show that to you in the regulation itself.
Thank you.
But your lordship is right. If it had been a community carrier, then conceivably there may be difficulty, although I think the fact that it is to the UK
would have covered it. Thank you.
Regulation. So, my lord, I think what I'll do then with ground two is I'll first explain the pre-IPCD position and the scheme of the 2018 Act, and then I'm going to try and suggest the correct approach to apply to a 261 case, which will include an analysis of the umbrella interchange case, and then I'll finally look at the consequences for the proper interpretation of the regulation. That's how I'm going to structure my submissions on ground two. So, turning then to the scheme of the 2018 Act, and again, just for your reference, there is quite a helpful article in the Law Quarterly Review that it gives a background of the legislation retaining EU law, and that's an article by Simon Whittaker in the 2021 Law Quarterly Review, and you'll find that in the authorities starting at page 1887. And I think the passages between 1887 to 1893 are quite a helpful background analysis for those who are not steeped in this already. Prior to the UK's departure from the EU, the regulation formed part of the domestic law of the United Kingdom by virtue of Article 288 of the Treaty of the Functioning of the EU and Section 2.1 of the European Communities Act 1972. And again, for your note, that's in the Supplementary Authorities Bundle at page 153. And it was obviously directly effective. And under the 2018 Act, it's referred to as direct EU legislation. And one sees that at section 3.2 of the Act. Again, that's page 9 of the authorities bundle. Now, this court held in the case of Miller that the ECA, European Communities Act, was a conduit pipe through which EU regulations flowed into domestic law. And the passage showing that is at paragraph 65 of the decision, and that's in the authorities bundle, page 757. And perhaps we could just turn that up. And it's an important passage because it's certainly relied upon in the subsequent authorities, which is at 65. In our view, then, although the 1972 Act gives effect to EU law, it is not itself the originating source of the law. It was, as was said on behalf of the Secretary of State, echoing the analysis of Professor Finnis, the conduit pipe by which EU law was introduced into domestic law. So long as the 1972 Act remains in force, its effect is to constitute EU law an independent and overriding source of domestic law. And then just whilst you have that open, at page 759, paragraph 70, that there is then an analysis of the rights under EU law, and particularly those that are replicated in UK law. And it then, again, if I could just invite you to read that paragraph and take particular note to the section at letter E. And certainly the expectation there was that upon withdrawal and the legislation that's passed, various rights, including EU regulations or directly under the EU treaties, will cease to have effect upon withdrawal. But importantly, there's a saving there, at least an expected saving, in relation to rights and liabilities already accrued, and that's the bit in brackets. And then, but many could be replicated in a new statute, for example, at that point, as proposed by the Great Repeal Act. And certainly the expectation in that case, at that point in time, would be that the EU legislation would cease to give any effect, would cease to have any effect, but accrued rights would be treated, or would have a different treatment. So if we then go very briefly through the 2018 Act and the supplemental authorities, and that's at, as I said a moment ago, it starts at page 2. And at page 3, one sees then that the Act, the European Communities Act of 1972 is repealed in section 1, and that's at page 3. So the conduit pipe effectively comes to an end then. But because of the withdrawal agreement, one has section 1A that was inserted, which saves the European Community Act, and that's at page 4 for the implementation period. But it then repeals it on the IP completion day, which was the 30th of December 2020. And obviously the aim of this was to give some legal certainty during the transition period. Now, in order to achieve legal certainty after the implementation completion day, the Act effectively adopted the entire body of EU law, but provided the government with powers to remove and or amend specific provisions of that law by secondary legislation. So one sees that at sections 2, 3 and 4 of this Act. So if one turns on to section 2, that's at page 8, what you see is that there is a saving for EU-derived domestic legislation. In other words, legislation that gives effect to EU directives, for instance. and it says that it continues to have effect in domestic law on and after IP completion day. Section 3, and that's at page 9, deals with the incorporation of direct EU legislation. And again, at subsection 1, it forms part of domestic law. Subsection 2 then defines what is meant by direct EU legislation, and that includes any EU regulation, EU decision, or EU tertiary legislation. What you don't see here is a reference to any rights that are separate from the regulation itself, for instance. And then section 4, and that's at page 12, then saves for various rights, etc., under section 2.1a of the ECA. And that deals with any, subsection 1 then, any rights, powers, liabilities, obligations, restrictions, remedies and procedures which immediately before IP completion day were recognised, etc., and or in force, and then they continue to be recognised. So this is quite similar to section 2.1 itself of the ECA.
The majority of the Competition Appeal Tribunal in the umbrella case thought that this transposed accrued rights.
It did, but the difficulty with that analysis, and I think Mr. Justice Ross focused on that, is then if you look at subsection 2 of this provision, it says that subsection 1 does not apply to any rights, powers, liabilities, obligations, etc., so far as they form part of domestic law by virtue of section 3. And obviously we've seen section 3 is dealing with directly effective EU law like regulations. So in this case, you have a right that is actually derived from a regulation and would appear to fall within the ambit of section 4.2, and for which there is no obvious express provision made in section 3 to apply.
Thank you.
Section 5 then creates various exceptions to the preceding provisions. And so what one sees, for instance, that it wouldn't apply to the Charter of Fundamental Rights at section 5.4. And then one sees it, and I'll come back to this because it's then picked up in one of the schedules that deals with retrospectivity. Section 6 then at page 18 of this bundle then deals with the question of interpretation of EU law. And it provides for various rules. And again, your Lordships will see that at section 6.1, that a court or tribunal is not bound by any principles laid down or any decisions made after IP completion day by the European Court, and cannot refer any matter to the European Court after that day. And there's no reference here to, in this particular provision of section 6.1, to retained EU law. There is obviously in the title, and I'll come back to that, but there is no suggestion that the exclusion here, or the direction here, is limited only to retained law in the text itself.
And is retained EU law a defined term in this Act?
It is.
Where do we see that?
It's over the page, at page 19, subsection 7 of this Act, which is means anything, your Lordship will see it's probably about halfway down. Retained EU law means anything which, on or after IP completion day, continues to be or forms part of domestic law by virtues of section 2, 3 and 4, or subsections 3 or 6 above.
Sorry, I'm 07.
It's not, it's section, is that section 16, is it?
It's section 6, subsection 7.
Sorry.
And what is brought forward as retained EU law by section 3 is the law as it stood immediately before completion day.
Correct. But absolutely right. So we would say, and it would be our submission, that it couldn't be the amended English regulation. All it could be would be the bare EU regulation in its form that was transposed across, and then after that scintilla of time, was immediately amended, but it's at that moment that it applies.
Yes, because Section 3 could have said what is retained EU law is as it was immediately before, but then as amended by enactments coming into force at the same time. But it doesn't say.
It could, but it didn't. And there are further provisions I'll come on to about that deals with retrospectivity about curing deficiencies. So, but I accept that it could, and that's certainly our submission will be that if it is anyone that applies, it is the one that the bare version of it, as I can describe it.
You say that sections. I'm sorry.
No, go ahead.
You say that section 6.1 applies to both accrued and retained.
Yes, we
right.
do. And we'll say that that's as a matter of construction of this provision. And the heading is informative but not binding. And in fact, you need to give the language the meaning and effect. I'm sorry, my lady, you had a question.
No, that was my
Great
question.
minds thinking alike. Right. So, your lordships will then see with the remainder of section 6 sets out at subsection 2 that you may have regard to anything done on or after IP completion date by the European Court or another EU entity, so far as that's relevant. And then it tells you how to deal with retained EU law at subsection 3. And then subsection 4 says that this court is not bound by any retained EU case law. So that is any European Court of Justice decision that predates IP CD.
Very sorry, which provision are you in now?
Section 6, subsection 4, page 17. The Supreme Court is not bound by any retained EU case law. And retained EU case law is defined over the page 19. That means any principles laid down by and any decisions of the European Court of Justice as they have effect in EU law immediately before IP completion day. And then it's so far it relates to any sections 2, 3 and 4, etc. Section 7 of this Act, which is at page 21, then sets out the status of retained EU law. And effectively gives it effect by this section. And then section 8 at page 30 allows for various deficiencies to be dealt with from withdrawal, and that gives power to the Minister of the Crown to make regulations to remedy or mitigate any failure of retained EU law to operate effectively or any other deficiency in retained EU law, and defines in subsection 2 the deficiencies in retained EU law and where they arise. And then subsection 4 at page 31 sets out that retained EU law is not deficient merely because it does not contain any modification of EU law which was adopted or notified or comes into force or only applies on or after IP completion day. But subsection 7 then is important but the regulations under subsection 1 may not, and then it's subsection B, make retrospective provision. So if one analyses the amended passenger regulation, as I'm going to call it, as perhaps trying to deal with any deficiency that has been identified, and in particular one deficiency would be the jurisdictional scope of its application, then that amendment was obviously made at the same time as it came into effect, but by this provision, the minister wouldn't have had power to make that retrospective. And what effectively you see here, my lords and ladies, is that the 2018 Act created a new sui generis body of retained law that was subject to its own rules of interpretation and rules for amendment. Now, when one...
Subject to your point on Section 6.1, do any of these provisions address accrued rights?
No. Subject to Section 6.1. I mean, Section 6 also precludes any reference to the European Court of Justice. So that's the point that is identified in the umbrella interchange case, which is if there is ambiguity or a point that is not act clear, the previous ability to refer the matter to the Court of Justice for a determination is no longer available. And our submission on that is consistent with the regime and the withdrawal. For any accrued right, it's now left to this court to decide the point, applying the principles as existed. It may be in some cases as divergence. It may be that if there is a subsequent EU decision on the point, this court has the ability to take account of it.
And can you just help me? Why doesn't Section 4 on page 12 cover what we're calling accrued rights?
Because Section 4, subsection 2, and that's page 12, says that subsection 1 does not apply to any rights, powers, liabilities, so far as they form part of domestic law by virtue of Section 3. And Section 3 deals with the EU regulation rights. And so in this case, the accrued right to bring a claim for relief under the EU regulation is one that falls under Section 3 and not this Section 4.
So that's just in this case?
That's in this case.
My Lord Lloyd Jones asked you if there was any other provision dealing with accrued rights, and absent the fact that this is a regulation case, 4.1 does deal with.
Yes, I'm sorry. Yes, 4.1 would deal with more broadly. So if you had, for instance, rights that arose under an EU directive that had been given effect by legislation, then that would be dealt with by Section 4.
Thank you.
And then when one gets into the definition of retained EU law, page 19 in section 6.7, does that not cover, at least to that extent, accrued rights under Section 4?
I think I would accept it would cover accrued rights under Section 4.
So, I mean, we seem to be trying to operate with a distinction between retained rights and accrued rights, but as retained EU law is defined here, it seems to cover both categories, does it?
So, I mean, I think that certainly when it's difficult to see how it could cover the category of a right that is directly effective that would come into play within Section 3. I would accept that it would apply to a Section 4 right.
What kind of rights are they talking about in Section 4? It's not a right under domestic legislation implementing a directive. It's not a directly applicable right under the treaty or under a regulation, because that's dealt with in Section 3. So what is this? Is this, for example, a claim against the government for failure to implement a directive properly, or what sort of right are they talking about here? Because it doesn't seem that it's likely to mean that there are no accrued rights for under regulations because of the exclusion in 4.2.
mean, perhaps the easiest way is to look at this in the way they look at it in the umbrella interchange case, and I'll come back to that. But I think Section 4 is trying to look at rights that I mean, if one takes, for instance, a directive that has been implemented into the UK by some form of statutory instrument, that is still dependent on there being a European right that imposed an obligation on the UK to implement that directive. And if that has now been withdrawn, then conceivably there could be a lacuna there, and that's what I think this is trying to deal with.
So Section 4 is saying this deals with all sorts of rights that you had under Section 2.1 of the ECA, but carves out Section 3 because that's dealt with in Section 3.
Correct. That's effectively what it's saying. And I think that the judgment of Mr. Justice Roth on this point is particularly illustrative, and I think that does seek to show the limitations of relying on Section 4.
And why isn't Section 3, why doesn't it include a set of accrued rights? It seems a bit odd if Section 4, as you accept, covers, at least to some extent, what we're calling accrued rights, but then carves out Section 3. The logic, I mean, as best I can see at the moment, the logic behind that is because those accrued rights are already covered by Section 3, so you don't need to bring them within Section 4.
I think because it doesn't expressly refer to rights, it simply refers to the regulation itself.
Yeah, but you get rights under a regulation, don't you? That's what individual claimants are interested in, their rights.
And I can see that. Well, I think one has to then read into that is inclusive of rights, which again is not really how, for instance, the judges in the umbrella interchange analyse Section 3. I think that is sticking more to the legislation itself.
Sorry, I'm slightly at a loss here. Surely the point of looking to see whether EU legislation is retained is to see whether rights which arose under that legislation continue to be available, whether going into the future,
yes,
so a flight after IP Day, or in the past, if you've already got a right under a regulation, why doesn't Section 3 preserve that right?
Because I think, well, Section 3 doesn't expressly say that a right that arose prior to IPCD was one that is transferred across. What it's saying is that the regulation is transferred across.
Change the page. Doesn't work.
I think what I'm struggling with is your attempt to differentiate transferring the regulation from the rights under the regulation. They seem to be part and parcel of the same thing.
But I think, well, it depends. So I don't think there's a difficulty with seeking to enforce a right after the implementation day, IPCD, because that's a right that clearly has been transferred across. The question is if you had a pre-existing right before the regulation was transferred across. I don't think it follows from the language here and what's being transferred across that extends to a right under that.
Well, Section 3.1 says direct EU legislation so far as operative immediately before IP completion day forms part of domestic law after IP completion day. So direct EU legislation operative immediately before IP completion day will have conferred rights on people. So they may have accrued rights.
Yes.
Through operation of direct EU legislation, does Section 3.1 not have the effect of carrying the legislation and all the rights that it's created along with it, so that they form part of domestic law after IP completion date?
Again, I can see the logic of that, but I don't think it didn't strike me as an obvious reading of that, and it didn't strike either any of the judges in the umbrella interchange case as the obvious reading of that. But
is there a difference between a rule and a right arising under a rule? It may be the 3.1 applies to the rule, whereas Section 4 is addressing
deals with the right,
some rights arising under some rules, but not arising under regulations.
My Lord, I think that may be an important distinction.
But what's the logic of that?
Well, I'm not sure that the legislator necessarily addressed rights that had arisen before that had been articulated.
And there's nothing in Schedule 1 that helps us. Somebody's looked at that.
Schedule 1 then deals, and I'll come back to that. Schedule 1 deals with some provisions that, for instance, Frankovich rights are excluded, and it deals with that. But if I perhaps come on to that.
I'm so sorry to take up time with this, but I'm just looking at Section 4.2. It says, subsection 1 does not apply to any rights, powers, liabilities, obligations, restrictions, remedies, or procedures, so far as they form part of domestic law by virtue of Section 3. So that seems to contemplate that you can get rights which form part of domestic law by virtue of Section 3.
I would accept that. I agree with that.
So that takes us back to the point of puzzlement for me. How do you seem to be trying to draw a distinction between the rule and the right under the rule. But, I mean, speaking for myself, I have difficulty with that distinction anyway, but doesn't Section 4.2 tend to show that that's not intended to be a distinction which is relevant for the purposes of the operation of this Act?
Except, although they dealt expressly with that in Section 4.2, it's not been replicated within Section 3.
But that can't mean, if that's right, then either all those rights just disappear, or they're still enforceable, as your case is, they're still enforceable under the Interpretation Act, Section 16. Actually, Section 2 of the ECA has this unexpectedly long afterlife of giving everybody rights in respect of things that happened before exit.
I mean, I think that is the effect of the Interpretation Act, and it's a limited right in the sense that it's a right that is subject to Section 6, for instance, and how that's then modified, the approach that the courts take. I mean, one sees in Section 16 of the Interpretation Act that it is...
Sorry, where do we have that?
That is in the authorities at 1138.
In the main bundle?
The main authorities bundle, 1138. And again, what it says is that where an act repeals an enactment, the repeal does not, unless the contrary intention appears. And then it's subsection B, affect the previous operation of the enactment repealed or anything duly done or suffered under that enactment. And then C, affect any right, privilege, operation or liability acquired, accrued or incurred under that enactment. And so our submission is that...
Well, yes, if you're right, then that section has a very fundamental impact on this whole regime. But is there anything you can show us that indicates that it was the intention that the Interpretation Act would do this amount of heavy lifting in respect of pre-Brexit events?
We have not found anything that shows that.
I mean, instinctively, one might think that the Withdrawal Act was supposed to do, as my lady puts it, the heavy lifting, so that one would look for the relevant answer there.
I mean,
but there doesn't seem to be any express provision in the Withdrawal Act which deals with accrued rights.
No, at least under the regulation.
Right, unless, I don't want to rehearse again the debate about Section 4 and Section 3.
I mean, within the 2018 Act, as my Lord Jones says, that there isn't anything that expressly deals with accrued rights, nor are there transitional period provisions which expressly state that retained law is to be applied retrospectively, or that any directly effective EU legislation enforced prior to IPCD should not continue to be applied to matters arising before that date. I mean, there are provisions in the Act that deal with retrospectivity, and perhaps it's worth looking at that, because that's certainly relied upon in the umbrella interchange judgments. And that you'll find in the small supplementary bundles authority at page 110, and the clearest, and it's Schedule 8. And so at page 110, it's section 39.1 of this Schedule 8. Makes clear that subject as follows and subject to, and then it identifies various provisions. Any provision made by regulations under the Withdrawal Act, Section 5.4 and paragraphs 1 to 4 of Schedule 1, apply in relation to anything occurring before IP completion day, as well as anything occurring on or after IP completion day. So Section 5.4 is the abolition of any charter rights. Paragraphs 1 to 4 of Schedule 1 deal with the right to claim Frankovich damages. And so one has there an example.
Sorry, where do we have that in the bundle?
Just bear with me for a moment. It's page 42 of the same bundle.
Thank you.
And so one sees there that having abolished those rights in the main legislation, there is then a preservation of retrospective rights. And again, what we...
If it makes provision for those things which are quite rare, it would be very strange not to make provision for a much more common occurrence of somebody exercising or somebody suing on the basis of a right arising under directly applicable regulation.
I mean, I can see that. I think the distinction here is that because there is an express abolition of the right, on both those rights, there is then a saving for limited examples or limited circumstances given in Schedule 8. But what we say is that shows that the legislature applied its mind directly to where it wanted to save, where it wanted the legislation to apply retrospectively. And where it doesn't address that, then you are back in the Interpretation Act. Perhaps I could take you to the umbrella interchange case, and you can see the arguments that were relied upon by the judges there. I'm sure your lordships are familiar, at least
Just
from...
before we go there, as I understand it, the bottom line as far as you're concerned is there is a concept of accrued rights under EU law that they continue as they would have done, subject to, as I understand it, you're saying, Section 6, where one must interpret the accrued rights in the same way as one would interpret retained EU law. That is, one is not bound by any subsequent EU decision of the European Court of Justice, and there's no reference approach. Is that, in a nutshell, where you stand?
That's correct.
Yeah.
So, what is the difference then that you seek to rely on in saying whether it's retained or accrued, whether it's a retained right or an accrued right? Is your concern that if it's treated as a retained right, then the Court of Appeal seems to have said, well, it must be then as amended by the 2019 regulations?
I mean, that essentially
but
is...
But then I thought at the outset you were saying, well, it can still be a retained right, and Section 3 says that those are retained, the law immediately before completion date.
My lady, it is to identify the correct version of the retained right.
But I'm not sure that turns on whether it gets this badge of retained or accrued, given the wording of Section 3.
No, I think the difficulty is that a scintilla temporis type argument is always a pretty unattractive one, in the sense of, it was there for a moment in I'm going to call it the bare form, but it then is amended immediately.
But in a sense, it's not a scintilla temporis, because it's carrying with it whatever rights have accrued in the period down to that point in time, isn't it?
Yes, I suppose. I mean, I think that's correct. On that hypothesis, that's correct. It's just that it is immediately amended prospectively. And
right.
So,
but I mean, the very fact that the amendment is prospective, you can accept that there's a prospective amendment because you're concerned with your client's rights, which arose before that amendment.
And it's just identifying which in the new world is the correct version, a piece of legislation you apply, rather than the amended regulation, one would have to then look back at, I suppose, you have to find the original one, or you just have to have a fiction that it was the same as the EU regulation, but without EU in front of it, effectively.
Thank you.
I mean, it's
the difficulty is that what Section 3 doesn't say is that it's treated as being domestic law and as if it was always domestic law. If it had said that, then you would have said, okay, so any rights that accrued under the regulation are treated as if they were rights that accrued under domestic law. But in fact, they were rights that accrued under domestic law because that legislation was directly applicable within domestic law. So it's not that, well, anyway.
Perhaps, I mean, I think I've...
Yeah, I'm so sorry, but just to pursue what my lady was saying, if one looks at section 3.1 again, which is page 9 of the supplementary bundle, isn't that predicated on the idea that directly effective regulations were indeed part of domestic law before IP completion date? Because it says, so far as operative, immediately before IP completion date. Surely that means operative in domestic law before IP completion date.
I accept that. I think that is correct. It's just what's the question is what's encompassed within that in relation to any cause of action that has risen under that.
I've asked this too much, but just for the last time, just explain to me why you say section 3.1 does not carry forward as part of domestic law rights which came into operation prior to IP completion date under an EU regulation.
I think it's because what is being addressed there are the question of the rule itself, the law itself, as opposed to any rights derived from
I see.
that
It's
law.
back to that distinction.
I'm afraid I don't have a better answer.
No,
So
that's what I wanted
saying
to
what
check.
this is dealing with is the repeal of section 2, which was the conduit, and it's saying this law doesn't all disappear after completion day, but you say that what happens after completion day in relation to facts that arose before completion day is effectively still dealt with under the ECA by virtue of section 16 of the Interpretation Act.
That's a submission, yes. And that was, one sees that dealt with in the interchange decision, and that's in the authorities bundle, the main authorities bundle at page 954. And then just for your note, I mean, the nature of the claim and the key issues are at page 954 at paragraph H3. But just to summarise, this was a claim for damages of infringement of Article 101 of the TFEU by two payment card scheme operators in relation to terms of multilateral interchange fees. And what the claimants argued in that case was that, first, a post-IPCD EU judgment, which was referred to as the Volvo decision, supported their case that the limitation period for all claims under Article 101 did not begin to run until after the infringement ended. Second, their claims accrued prior to exit day, and therefore EU law and not retained law should be applied to them. And third, they argued that if EU law is applicable, then the courts are bound by post-IPCD EU decisions, notwithstanding the wording of Section 6.1 of the 2018 Act. And as your lordships have seen, the CAT disagreed, not only on the construction of the Volvo decision, but also then in relation to the status of the legislation. And you have the majority judgment of Marcus Smith, Mr. Justice Marcus Smith and Ben Tidswell, and then the minority of Mr. Justice Ross. Now, your lordship should be aware that on the 4th of December 2023, the CAT granted the claimants permission to appeal that to the Court of Appeal, both on the Volvo decision and also on the status of the applicable accrued and retained law. The two judgments in the CAT both held that accrued EU law rights do not exist, and that to the extent there are any issues for retrospectivity, they're addressed by the 2018 Act itself, and therefore there's no role for the Section 16 of the Interpretation Act. But what the CAT didn't do was expressly address the issue of rights accrued under the direct EU legislation, which was not at issue in the case. And the essential reasoning of the majority is at paragraph 69, that's page 1001, and it's really paragraphs 69, subparagraphs 1 to 4. And essentially at 69.1, they observed that there'd been the fundamental shift in the legal order, and the litigation of claims must reflect that reality, particularly given that references to the European Court are no longer possible and EU law is no longer supreme. And then their concern was that the application of EU law to matters arising pre-IPCD would create a procedural vacuum, and one sees that referred to at paragraph 69, subparagraph 2, Romans 3 and 4, and it would also create confusion where facts straddle IPCD, pre and post IPCD, and that's paragraph 69 to Roman 5. The next point that they dealt with was to say that they made the point that the 2018 Act repealed the conduit rather than any EU law itself. And their reasoning, one sees, was that the rights there were preserved by Section 4 of the 2018 Act, which translates...
Which subparagraph are you on?
Sorry, it's section 69, subparagraph 3. Your Lordship might see just at the lower part of that. It says the Section 16 of the Interpretation Act doesn't really apply. Deals with this, whilst the 72 Act has been repealed, that repeal affects only the gateway. The rights themselves by which we mean not merely the directly effective Article 101 TFU, but any accrued claims under that directly effective provision are preserved by Section 4.1 of the 2018 Act. Does Your Lordship have it?
Yes, thank you.
So one might interpose, jolly lucky it was a claim under the article rather than a directly effective regulation. Because Section 4.1 just happens to apply to an article claim rather than a regulation claim.
Well my Lord, Mr. Justice Roth thought not. So I'll take you to that in a moment. But yes, from their reasoning, that's correct. And third, what said at paragraph 69, subparagraph 4, was that the scheme of the 2018 Act was to transfer all EU law and rights into domestic law, primarily without substantive change. So again, there was no scope for the Interpretation Act to operate. Now, my Lord, if one then turns to the judgment of Mr. Justice Roth, and one sees that that picks up at page 1013 of the electronic bundle. And it's paragraph 84 is one that I have considerable sympathy with, because it says, he explains why he's giving a concurring judgment. And on the what he says about two 2 sentences in, is that on the distinct issue regarding the implications of the Brexit legislation, which arises only if we're wrong in our interpretation of Volvo decision, which I agree with on the outcome, I have not found that an easy matter to resolve and reach my conclusion by reasoning that is somewhat different from that of the majority. And so one then picks up at, again, paragraphs 90 through to paragraph 98. As Justice Roth sets out quite a helpful background again to the Withdrawal Act and the Miller decision. And then at paragraph 99, page 1017, retained EU law can be regarded as encapsulating EU law effectively frozen, as at IPCD. And then at paragraph 100, Mr. Justice Roth begins by noting that retained EU law is forward-looking and that the 2018 Act does not contain a clear answer to the question of how accrued rights are to be dealt with. And one sees that at paragraphs 100 and 101. And 101...
sorry, just on the idea that retained EU law is forward-looking, I think you've agreed that not all of it is, because Section 4 includes rights already accrued, which is backward-looking.
Yeah, I think...
So you're showing us this. Are you asking us to endorse the majority or the minority, or is this just for our interest?
I'm just showing you as to how this has been... I'm not asking you to endorse the majority view. In fact, my case is contrary to their view.
So are you inviting us to endorse Mr. Justice Roth's view?
No, I'm just trying to... I'm not. I'm saying that both the majority and Mr. Justice Roth were incorrect.
Right. Okay.
But just so that you can see how he dealt with Section 4.1, paragraph 101. So to that extent, I am asking you to endorse Mr. Justice Roth in that Section 4.1 doesn't provide the route to the rights derived up from the EU regulation. And your lordships will see that he starts...
That's almost the reverse of the point that I was putting to you, because I was sort of putting to you, well, if Section 4 is catching some accrued rights, it would be very odd if rights under directly effective regulations were not caught. The underlying tenor was surely they're caught by Section 3.
Yeah.
And this is sort of saying, well, it would be most odd if rights under EU regulations are not within the Act, but that shows that nothing's within the Act, or you have to treat breaches of the treaty, in effect, as not accrued rights either.
Well, I think that's why he then says at paragraph 102, notwithstanding that Section 4.1 doesn't provide the route, he says that taken as a whole, the scheme has in effect converted or translated rights which had accrued under EU law.
So which provisions do that?
Well, that's the problem with his judgment.
Right.
That's why we're not endorsing it. I mean, effectively, as your lordships have identified, there are two plausible candidates for transferring the rights across. The one is either Section 4 or Section 3. We say Section 4 doesn't apply to a regulation because of the exclusion. But the majority said that Section 3 operates, so they have made the distinction that operates to incorporate direct EU legislation into domestic law, that's the rules bit, but does not operate to incorporate rights accrued under that legislation.
Sorry, which paragraph is that?
So one can pick that up. You have to go back, I'm afraid, to page 988. And so page 988 is effectively the majority's analysis of the Withdrawal Act.
That paragraph. Which
starts at page 986.
I think it's paragraph 44.
It is paragraph 44.
44 to B.
And
Sorry,
it's
we're on-
44.3, Roman 3. Sorry, 44, subparagraph 2.
I'm sorry, we're on page
Sorry, we're page 987.
987.
Paragraph 44 starts on the previous page.
Yes.
And then subparagraph 3.
Little Roman 3.
Little Roman 3,
Right.
987.
So that's paragraph 44, subparagraph 2, subparagraph Roman
Correct.
3. Yeah.
Roman 3. And then it's subparagraph, another subparagraph of that C and D, which is on page 988. And that's where, effectively, their summary is that Section 3.1 of the Act, the translation is limited to direct EU legislation, as defined in Section 3.2. It does not extend, for example, to a cause of action that might have accrued out of the rights conferred by direct EU legislation.
Why do they say that? Yeah.
Yeah, why not?
I think because they took that to be covered by Section 4.
No, but you have shown that it's very, very clear. Section 4 carves out Section 3.
Correct.
And everyone seems concerned about the different, a difference between rights that you have for breach of a treaty, for example, and rights which you have for breach of a regulation which is directly effective. Everyone seems bothered by drawing distinctions between them so far as being able to enforce after IP completion date in respect of causes of action that you had beforehand. So
it comes back to the question that your Lordship has asked previously, which is whether Section 3.1 includes within it the accrued causes of action as part of what's transferred over. And I think the fact that the legislation itself doesn't, in that section, refer to the more broader language used in Section 4 of all rights, etc., that's the reason why.
Why do they need to be carried forward? They exist in domestic law. They were domestic law rights before completion day.
They were, but to what piece of legislation do you then refer for their enforcement after completion day? Do you, I mean, for instance, if you were to plead a case and start a case today for a flight that happened in 2019, would you plead your case under EU Regulation 261 because that was the law at the time? Or would you have to plead your case under the their retained regulation in place? Would you then assume or look to the fact that that regulation will be exactly identical to the EU regulation?
why wouldn't you plead it by reference to the norm that actually applied at the time of your flight? In other words, the first of the examples you've given us, that was the law that defined your rights at the time, and it was those rights that were breached. One might think that's our case. They should apply that. Yes.
But the effect of the judgment in this case is to say that, in fact, my rights for that flight no longer arise out of the regulation, but arise out of the version that's been retained.
Right.
But
then I'm still slightly unsure why, in answer to my lady's question, you seem to be straining to say, well, it can't be Section 3.1 that has that effect, or that those just our rights. Section 3.1 contemplates that this law was operative and created rights before completion day, and contemplates that you can just enforce them after completion day.
I think, well, I mean, I don't think I have a better answer to give as to why Section 3.1
right,
doesn't,
okay, yeah,
from
all right,
what I
thank
gave you before.
But your case is not that these rights all disappear.
No.
Your case is they are rights that remain under Section 2 of the ECA, carried forward by the Interpretation Act, and that therefore the version that applies is the pre-Brexit version.
That's my case. It may be that.
But I think what they decided in the umbrella interchange case was this: that still the law that applied. Oh, did they have to decide whether it was pre-Brexit or post-Brexit law that applied?
They didn't have to decide because they said the case that was being relied upon
Right.
didn't, but they said that if it had applied, it would be the post-Brexit, the retained position, as opposed to.
So it would be they could have regard to it, but would not be bound by it.
Yes, that was the position of this CAT. I'm just going to move on just very.
Mr. Sharp, well, we've caused you to go out of order of your submissions, and I have it in mind that you only have until 22:1, according to the allocated timetable.
I might eat a little bit into my reply time, but I will certainly.
You can certainly eat into your reply time if that assists.
I'll do a little bit of that. There's just one final point on this ground, which is if we're right, how does Section 6 apply to any post-EU decisions? Post-implementation day EU decisions.
Yes.
To which we say that Section 6 is in fact applicable to those decisions because of the language that's used in Section 6. And notwithstanding that the title says retained law, when you look at Section 6.1, it clearly is not constrained to retained law. And again, there's authority as to the nature of a heading, but I don't think I need to take this court to that. But what we say is Section 6.1a is expressed clearly enough to meet the requirements of Section 16 of the Interpretation Act, and that it operates in respect of any rights that is enforced in the UK court, whether it's under an accrued EU right or indeed a retained right. And that's because it's expressed in general terms that the courts are not to be bound by any decisions made on or after IPCD. So that language is pretty clear. And Section 6.1a should be interpreted consistently with Section 6.1b, which precludes any reference to the European Court of Justice, which, again, is an obvious consequence of no longer being a member of the EU. You lose the right of reference.
Well, the machinery is no longer there.
The machinery is no longer there. But as a result of that, this court, by virtue of Section 6.1, is not obliged to follow blindly any subsequent European Court decision. Lords, I'm going to go back now to ground one. So this was a case which proceeded before in the county court before on the small tracks scheme, and it was dealt with without any difficulty. The evidence that was before the court in this case was a one witness statement which had some contemporaneous documents identifying the incident. So insofar as there are complaints about granularity, that didn't occur in this case, that there wasn't an overly extensive evidential inquiry that took an inordinate amount of time or court resource. It was dealt with just as any other small claims case. The one issue that that hasn't been an issue in this case, but is obviously important to your Lord and Ladyship's analysis of the Article 5.3 defence is the all reasonable measures provision. And that's a provision which applies and is a further burden on the air carrier to demonstrate that notwithstanding the delay has been caused by extraordinary circumstances, it nonetheless couldn't have avoided the cancellation by taking all reasonable measures. So that's a further limb. And just to bring in mind that that hasn't been an issue in this case, but it's very much relevant to your analysis.
But you have to succeed on both limbs.
You have to succeed on both limbs in order to engage the defence. So, my Lord, the legislative framework for passenger rights is threefold when it comes to carriage by air. The first is the Montreal Convention and its predecessor, Warsaw Convention, which gives passengers protection during the period of carriage by air. And there's a right to claim compensation for delay. But what it doesn't do is deal with non-carriage. The second are rights under the Package Travel Holidays Package Tours Regulation, which applies where a flight is sold as part of a package. And that gives various consumer rights where the package is not delivered and the flight element is not delivered. And both the Montreal Convention and the Package Tour Regulations have a limited defence for the carrier. We've summarised them in the written submission, but under the Package Tour Regulations, it's a defence for an airline to show that it couldn't supply its service due to unusual and unforeseeable circumstances beyond its control, the consequence of which could not have been avoided even if all due care had been exercised. And that was labelled in that regulation as a force majeure. But when it came to Regulation 261, they decided to, the legislators decided to adopt their own defence, which was the extraordinary circumstances defence, and didn't use the term force majeure. And so one has then the third area of passenger protection, which is Regulation 261, which came into force in February of 2005, and gives passengers rights in relation to denied boarding, cancellation of flights, and delay. And I'm going to look at the European version, which is in the bundle starting at page 425.
And this is the version which applied on the 30th of January 2018.
Yeah, it would have. It would, if it had been transferred unamended, this would be the version that would have applied as retained. There is an amended version which also came into force immediately after this one. But this was the version, but it's not materially different for my purposes.
But my question is whether this is the version that was in force at the time the rights accrued. You say the rights accrued.
Yes, I'm so sorry. Yes, it is. Yes, I
you.
misunderstood that. Yes, it is.
And also immediately before IP Day.
Correct.
Thank you.
And so page 425, there is a preamble to this, and it sets out at subparagraph 1 there's to be a high level of protection. Subparagraph 2 then deals with the identifies inconvenience caused to passengers. Subparagraph 3 then deals with denied boarding. And subparagraph 4 sets out that it's intended to raise standards and strengthen the rights of passengers to ensure air carriers operate under harmonised conditions. And then the way the protocol then divides is that from subparagraph 9 onwards at page 425 through to subparagraph 11, that's really dealing with denied boarding. Subparagraphs 12 to 14 then deal with cancellation. Subparagraph 12 makes the point that the trouble and inconvenience of passengers caused by cancellation of flights should also be reduced. And this should be achieved by inducing carriers to inform passengers in advance, and there should be a compensation except when cancellation occurs in extraordinary circumstances which could not have been avoided even if all reasonable measures had been taken. And then at paragraph 14, subparagraph 14, it then refers to, as under the Montreal Convention, obligations on air carriers should be limited or excluded in circumstances where an event has been caused by extraordinary circumstances which could not have been avoided even if all reasonable measures had been taken. And then it gives examples of political instability, meteorological conditions incompatible with the operation of the flight concern, security risks, unexpected flight safety shortcomings, and strikes that affect the operation of the operating air carrier. And paragraph 15 is a separate provision that deals with air traffic management decisions, where there's a deeming provision, but there's also then the reasonable measures requirement, even in that scenario. The definitions then, in Article 2, don't extend to extraordinary circumstances. That's at page 427. And then Article 3 deals with the scope, which applied at the time. Article 5 at page 428 then deals with cancellation, and it effectively requires the carrier at subparagraph 1 subparagraph A to offer assistance to the operating air carrier in accordance with Article 8, assistance in accordance with Article 9, and then the right of compensation under Article 7, unless, and then it deals firstly if there's advance notice given, and there are various provisions if advance notice is given. And then at subparagraph 3, if advance notice hasn't been given, it's an operating air carrier shall not be obliged to pay compensation in accordance with Article 7 if it can prove that the cancellation is caused by extraordinary circumstances which could not have been avoided even if all reasonable measures had been taken. So that's really the right that one's looking for. And Article 7 is the right to compensation. And you can see there at page 429 that it is a fixed amount based on the distance flown. Now, as originally enacted, this provision didn't apply to delay, but there's a subsequent European Court of Justice decision called Sturgeon, which has extended this right to compensation to lengthy delays over 3 hours, depending on the distance flown. Now, just for your note, the UK regulation, that there are only, before your lordships, there are only 2 versions. There is the current version, which is in authorities 4, beginning at page 432, which has been amended quite recently. And again, you don't need to look at that. But and then there is the version that was amended on introduction of the retention of the legislation, and that's in the supplementary authorities bundle. Page 120 of that bundle.
Thank you.
Again, it's not necessary to look at those because the relevant provisions.
Sorry, 432. That's an amendment of the EU regulation.
That's an amendment of the that's an amendment of the retained legislation. So the chronological order is that this was enforced pre-IPCD. It gets transferred across into English law by Section 3.2 if my Lord Sales is correct. It's then immediately amended by the version in the supplementary bundle, which makes it more UK-focused, if I can put it that way. And then subsequently there has been an additional amendment, which is the one that has been placed in page 432.
But this looks at 432. This looks like it's an EU instrument.
So I think they have retained the format, but you'll see in the title at 432, it's called Retained EU Legislation.
But it says the European Parliament and the Council of the European Union, having regard to.
I think the drafters, rather than trying to redraft it, has simply translated it across.
But you say this is a domestic...
This is domestic. And one can see that. If you turn, for instance, to page 439, the scope of this one, of this particular iteration, is limited to departures from an airport located in the United Kingdom. And then there are conditions where passengers are departing from an airport located in a country other than the United Kingdom to an airport situated in the United Kingdom if the operating air carrier of the flight concerned is a community carrier or UK air carrier. So that deals with the point which my Lord Jones referred right at the outset as to how this could apply.
Yeah, and you can see the footnotes go down to what clearly are domestic regulations,
yes.
which have amended them.
And what again, just for your information, what the legislator has done in this iteration at page 438 is to actually include its own definition of extraordinary circumstances. And the definition of extraordinary circumstances is very much taken from the case law that you're going to look at.
And did it amend it to include delay expressly?
It did include delay expressly, and one can see that.
So it amended it basically to make it UK applicable and also to incorporate within it where the case law had got up to.
Yes, I think that's
by IP.
I think that's a fair summary.
And did that amendment come in at the stage of the amendment on introduction, or only at the second stage?
It came in at the second stage.
Thank you.
The amendment on introduction, I'll just show you so you can see, is at the Supplemental Authorities Bundle, which is at page 120. Which again looks very similar to an EU regulation, but again you can see from the title it's retained EU legislation. And one can see at page 127 that the scope under Article 3, even at this stage, was restricted and much more UK-centric rather than the broader EU rights that one had under the EU regulation. So this would be the first amendment that was made.
Sorry, in fact, on that page, that seems to have been inserted by an amendment of this regulation. How does that fit? Because I think you were telling us that what we're looking at on page 120 is the regulation as amended on the IPCD.
It is.
But it itself seems to include amendments. That's just confusing me a bit. Page 127. You see there's square brackets around 1B, and then one looks down, and we see that substituted. Had this been amended before IPCD, and so this is the version that came into effect on the IPCD?
So this on IPCD, this came into effect, but it made amendments on IPCD. So the amendments that are shown are by reference to the original EU version. I mean, my understanding is I don't think there is a published retained version.
So this is showing what the amendments are to the EU regulation.
Correct.
Helpfully, even though they're
right.
It's not amending a previous purely domestic enactment.
Correct.
And the version which was in force for an instant hasn't been produced anywhere.
It hasn't.
There's no purpose.
No, no.
Thank you.
But it would be as good as the EU version, assuming that it's simply cut and paste across and then amended. The nature of the Article 5.3 defence has been described by the Court of Justice as effectively intending to strike a balance between the interests of the passengers and those of the air carriers. And that was in a case called Nelson, which is at page 575 of the authorities bundle, and the judgment is at page 591. And it's essentially, again, paragraph 39. I don't think I need to take you to it, but just for your note that the role of Article 5.3 has been considered as effectively to provide some sort of balance to the air carrier's interests. But as you'll see, the burden and the bar has been set high. So if I'm going to start first on this ground one with the relevant case law, then I'm going to have a look at how it applies to crew absence, illness, look at the Court of Appeal judgment very briefly, and then two post IPCD judgments of the EU. So the starting point and the critical case to understanding extraordinary circumstances is the Wallerton-Herman case, which is at page 1111. And essentially, this is a case where there was a technical problem that the flight was cancelled because of an engine defect discovered during a routine check, as a result of which the aircraft was not available. The airline argued for an Article 5.3 defence, saying this was extraordinary circumstances, and that was then referred to the Court of Justice, which dealt with basically all elements of the Article 5.3 defence. And so the questions that were referred for preliminary ruling are at page 1115, and that's paragraph 14. Your Lordships will see that there are 4 questions asked. The first is whether a technical defect which results in the cancellation of an aircraft gives rise to an Article 5.3 defence. And then 2 is a question dealing with whether there's that applies where the air carrier cites technical defects as a reason for flight cancellations with above average frequency solely on the basis of their frequency. And 3, if the answer to the first question is in the affirmative, has the air carrier taken all reasonable measures if it establishes the minimum legal requirements regarding maintenance work for the aircraft? And then 4 deals with if all those are a no, when does it apply? So the first and the fourth questions were considered together. And paragraph 17 at page 1116 makes the point that it's settled case law that the meaning, scope and terms for which the community law provides no definition must be determined by considering their usual meaning in everyday language, whilst also taking into account the context in which they occur and the purpose of the rule of which they're part. And then it deals with the need to be interpreted strictly. And then paragraph 22 at page 1117 deals with recital 14, and effectively, your Lordships will recall that that sets out a number of examples, but it makes clear that those are only indicative themselves, and that they may produce the circumstances, but not necessarily so. And then at 23, it then deals with technical problems. And the fact remains that the circumstances surrounding such an event can be characterised as extraordinary within the meaning of Article 5.3 only if they relate to an event which, like those listed in Recital 14, is not inherent to the normal exercise of the activity of the air carrier concerned and is beyond its actual control. And then it applies that to the technical problem in this case at paragraph 24. And makes the point that air carriers are confronted as a matter of course with technical problems. And that's why they have the maintenance. So what it then says at the end of that is the resolution of a technical problem caused by a failure to maintain an aircraft must therefore be regarded as inherent in the normal activity of the air carrier's activity. So one sees it's looking at the underlying cause of the problem. But it then at 26 makes the point that to the extent that a technical problem stems from events that are not inherent in the normal exercise of the activity of the air carrier concerned and are beyond its actual control, that would then engage the defence. And it gives various examples. So where if you have a manufacturer that reveals that there is a fault or a competent authority that identifies there's a hidden manufacturing defect which impinges on flight safety, that would be engage it. Equally, if there's damage to aircraft caused by acts of sabotage or terrorism. So technical problems can amount to extraordinary circumstances depending on the underlying source of the problem. And we see a summary as to the test that's applied at paragraph 34. And that is that a technical problem which leads to the cancellation of a flight is not covered by the concept of extraordinary circumstances within the meaning of that provision unless that problem stems from events which by their nature or origin are not inherent in the normal exercise of the activity of the air carrier concerned and are beyond its actual control. And then in the second question, it dealt with the question of frequency. And on the question of frequency, and that's dealt with the paragraphs, page 1119, paragraphs 35 through to 37.
Sorry, paragraph?
35 through to 37. But it's at paragraph 35, from C down, that it is apparent that frequency of the technical problem experienced by an air carrier is not in itself a factor from which the presence or absence of extraordinary circumstances can be concluded. And then the third question, starting at paragraph 38, just deals with the test and what the airline has to satisfy with the all reasonable measures requirement. And it's not enough for the carrier to show it complies with the minimum legal requirements. But at 41, the carrier must establish that even if it had deployed all its resources in terms of staff and equipment, the financial means at its disposal, it would clearly not have been able, unless it had made intolerable sacrifices in the light of the capacities of its undertaking at the relevant time, to prevent the extraordinary circumstances with which it was confronted from leading to the cancellation of the flight. So this was the first case that looked at this defence, and it makes clear that, firstly, paragraph 14 of the preamble provides examples of events that may but are not necessarily extraordinary circumstances. Secondly, it prescribes a test for extraordinary circumstances, which is to identify the event, here it was technical problems, identify its source or where it stemmed from, and then in order to qualify as extraordinary circumstances, it must stem from events which by their nature or origin are not inherent to the normal activity of the airline concerned and are beyond its actual control. It also makes clear that frequency of the event is not a relevant factor which the presence or absence of extraordinary circumstances can be concluded. And it then gave a definition for the all reasonable measures test. And effectively what that second limb does is that it means that only a subset of what may be described as extraordinary circumstances would engage the defence. It's only if you can show that second limb has been satisfied that you're entitled to the defence. And we would submit that those bars do not require the court or a court to take an unduly restrictive interpretation of the meaning of the language used, because there's already within the scheme protection for the consumers. Now, the question of technical defects was considered by the English Court of Appeal in the decision of Jet 2 versus Hussar, and that's at page 540 of the appeal bundle. So this is again another technical problem, but on this occasion it was one that was caused by defective wiring, which couldn't have been discovered through ordinary maintenance. And the first instance judge dismissed the claim, but in a way that wasn't followed by the Court of Appeal. But if one perhaps picks up the judgment of Mr. Lord Justice Elias, page 543, paragraph 3 gives you a much clearer explanation as to the nature of the technical problem, which is that B on that page, which was an unexpected technical problem on the inbound flight, and then at C, there was a wiring defect, and then at F, it was one that couldn't have been predicted by a regular system of inspection or maintenance.
So was it a manufacturing defect or what?
It wasn't analysed as one, and that's certainly not apparent from the judgment. So then the first instance judgment is then looked at paragraph 20, which is at page 548. And you'll see at paragraph 20 that the judge there interpreted Valentine Herman as saying that it is the consequences of the technical problem and not the problem itself which must be considered, and then sets out the analysis of the judge there. And at 21, Lord Justice Elias accepted that was mistaken, and that one has to look at the source of the problem, not the consequence or its resolution. And we endorse that and say that that is the correct approach to take. You start with the source, not how it's resolved. Paragraph, page 549, then, paragraphs 23, the issue that came up in that case was, well, how does one deal with the two limbs? There are three limbs in the extraordinary circumstances defence. There's one that it's not inherent to the normal activity of the air carrier. Second, it's not in its actual control. And the third is the all reasonable measures. So the first two, there was a question as to how those two interact with one another. And the submission that was being made was that they were combined, but that was rejected, and there's been subsequent case law to show that you look at each one individually, but that the second may lend colour to the first. And so one picks that up at paragraph 35 and 36, which is at page 550. That the appellant is in effect construing the test as events by their nature or origin are not inherent in the normal exercise of the activity of the air carrier because they're beyond its actual control. By contrast, the respondents are saying events by their nature or origin are not inherent to the normal exercise of the activity and are therefore beyond its actual control. And then at 36, the judge is saying is that proper understanding of the two limbs should focus on the concept of extraordinary circumstances itself. The language used in Article 5.3 requires that the circumstances must be out of the ordinary. As the CJE recognised in paragraph 24 of Volantine Herman, difficult technical problems arise as a matter of course in the ordinary operation of the air carrier's activity. Some may be foreseeable, some not. But all are, in my view, properly described as inherent in the normal exercise of the air carrier's activity. They have their nature and origin in that activity, and they're part of the wear and tear. And then there was a problem in the approach that was being taken by the air carrier in that case, which was to try and effectively establish a fault-based system, which the court was not prepared to accept. But 47 and 48 then look at the test to be applied, whether it's a single or dual test. And at paragraph 48 at page 553, the judge thought that it's a dual test, but that the latter informs the former. The written case sets out a number of the other authorities, and I'm not proposing to go through all of them, not least because I don't think I've got time to do so. But if I could just very briefly show you the Van der Lands case, which is at page 1030. Again, this was another technical problem, which was a premature, and that's at page 1030 in the held section, which was a premature malfunction of certain components, and whether that was constituted extraordinary circumstances. And again, the Volantine Herman approach was followed. And effectively, if one picks up the judgment at paragraph 37, there one can see that at page 1039, since the functioning of the aircraft inevitably gives rise to technical problems, air carriers are confronted as a matter of course in the exercise of their activity with such problems. In that connection, such technical problems which come to light during maintenance of the aircraft on account of failure to carry out such maintenance cannot constitute extraordinary circumstances. And then at 41, even though it's unexpected, what the court held was nevertheless that breakdown remains intrinsically linked to the very complex operating system of the aircraft, which is operated by the air carrier. And at 42 then deals with the inherency limb, that it must be held that in the course of the activities of an air carrier, that unexpected event is inherent in the normal exercise of the air carrier's activity, and then it's beyond its, is not beyond its actual control. Now, there are a number of cases that deal with aircraft damage and aircraft damage by third-party or extraneous events, one of which is a case called Peskova, and that's at page 605. And essentially, this is a case where an aircraft coming into land at an airport had a bird strike with its engine. It ingested a bird. And the aircraft was then inspected for damage, which led to delay. And then the air carrier itself called in for its own preferred engineer to come and inspect it, which added further delay. And so the question is which, if any, of those delays qualified as extraordinary circumstances. And what the court held was that the damage caused by the bird strike satisfied extraordinary circumstances, but that the delay that was due to calling in the second engineer was not extraordinary circumstances. And although it's not entirely clear from the judgment, it is my submission that the court analysed that as a failure to use all reasonable measures to mitigate the effect of the bird strike. And my lords, if one just sees how this was reasoned at paragraph 22, which is at 611, It starts off at paragraph 22 with setting out the Wallentin and Herman test. And then at 23 deals with premature failure of parts and why that's not outside the actual control. But then at 24, it deals with the fact that a collision between an aircraft and a bird, as well as any damage caused by that collision, since it's not intrinsically linked to the operating system of the aircraft, are not by their nature or origin inherent to the normal exercise of the activity concerned. And for that reason, the court held that that satisfied the inherency limb, and also it wasn't in its control. And then the rest of the judgment, which I won't go to, but deals with questions of reasonable measures, and that I don't need to go through at this stage. German Wings and Poles was another case where there's damage to an aircraft tyre caused by debris lying on the runway, and that's at page 510 of the bundle. And what happened here was that the air carrier identified that there was a damage to one of its tyres, and that it had been essentially it had run over a nail or something that was on the airport infrastructure. And the question was whether that gave rise to extraordinary circumstances. And one sees that from paragraphs 23 and 24 of the judgment, where essentially what the court said was that in this regard, it's common ground that aircraft tyres are components which are on landing and takeoff subject to very great stress and are subject to the permanent risk of damage, justifying particularly strict regular safety checks, and that's part of the everyday operating conditions. However, where the malfunctioning in question is the sole result of the impact of a foreign object, which must be proven by the air carrier, such malfunctioning cannot be regarded as intrinsically linked to the operating system of the aircraft. And it then applies Peskova. And then at 26, therefore, if the malfunctioning tyres is the sole result of impact of the foreign object lying on an airport runway, it cannot be regarded as inherent to the nature of the origin of the activity of the air carrier, nor in its control. So again, there it's looking at the underlying source of the damage to the tyre. In this case, it was the impact with a foreign object on the runway. So too in the Peskova case, what's the source of the damage to the aircraft? It's the impact with a bird. Similarly, there's a case of Moens versus Ryanair, where again, the aircraft, the delay was caused by the runway closure due to fuel spillage, and that was held to be extraordinary circumstances, and one sees that at page 568. And there was petrol on a runway which led to its closure, and consequently the long delay of a flight to or from the airport constituted extraordinary circumstances. That's in the headnote at page 568. And then picking it up at page 572, paragraph 17, again, adopts the Wallentin-Herman judgment, and then asks the question at paragraph 18, and concludes that it's not it's inherent to the operation of the aircraft, and looks back to the Germanwings case, and it's also beyond its control, and therefore in those circumstances concludes that it is satisfies the extraordinary circumstances requirement. But then paragraph 25 at page 573 emphasises the point that it's not all extraordinary circumstances that confer the exemption, and therefore the onus is on the air carrier to also satisfy the all reasonable measures requirement. And just the last case at this stage I want to look at is just the Cruiseman decision, and that's a decision on strikes and disruptive passengers. So Cruiseman is at page 518, of the main bundle. And this was a strike that essentially arose out of an unexpected announcement of corporate restructuring. And the carrier sought to rely on the fact that it was a strike as referred to in recital 14. And the analysis of the court effectively, one picks up at paragraph 29 at page 526. One sees the question there, which is whether effectively it was strikes in this case. They were wildcat strikes, but the strikes engaged the extraordinary circumstances defence. And then paragraph 38, I think is where I want to take you to, and it's 38 onwards through to 44, that effectively what happened here was that that the strike itself originated from the carrier's surprise announcement of a corporate restructuring, and that this is what triggered it. That such restructuring are part of the normal management of the entities, and therefore air carriers, as a matter of course, in carrying out their activity, face disagreements or conflicts. And that's just part of the normal activity of paragraph 42, and therefore it can't be regarded as beyond the control of the air carrier, and that's why it didn't qualify as extraordinary circumstance. So again, with this strike, what the court did was to identify the underlying cause of it, which here was an announcement of corporate restructuring, and then assessed the employee reaction as a complaint about terms and conditions that followed from it. And my Lord, what these cases show, in my submission, is that to establish the extraordinary circumstances defence, one has to satisfy two limbs. Firstly, the inherency test, and secondly, the actual control test. Those two limbs are cumulative, and the control limb can inform the inherency test. And that the application of the two limbs does require the identification and analysis of the source or origin of the event of the causes of the cancellation of delay. And so there is a causation analysis, but it's a fairly limited one. But the inherency test does require the consideration of, in the case of a technical problem or damage to aircraft, whether the source or origin of that event is intrinsically linked to the operating system of the aircraft or is a result of some external event. In the case of other circumstances, whether the source or origin of the relevant event results from events which are external to the normal exercise of the activity of the air carrier. And again, this is reinforced by the fact that the natural meaning of being inherent to an air carrier's operations is that the event is intrinsic to or a necessary part of those operations. If the air carrier's operations is disrupted by an external or extrinsic matter, the action of a third party, then the event causing the disruption, and thus the cancellation, is external to and not inherent in the operations of the air carrier. And the actual control limb looks to see if the source or origin is beyond the actual control of the air carrier, or the air carrier would include. Sorry, I misspoke. That is beyond the actual control of the air carrier. And the frequency of the relevant event is not a relevant consideration to categorise the event as amounting to extraordinary circumstances. Frequency may well be relevant when you come to look at the all reasonable measures requirement, as that could inform the measures which could and should have been taken once the delay had occurred. And as I said earlier, it's not every extraordinary circumstance that will satisfy that test.
So how are you applying the external point that you've made to our facts?
So obviously the same principles apply to our facts. And in our facts, a member of crew, when they're not at work, are effectively equivalent to a third party or an external event.
What, just because they're not at work?
Well, because they are effectively yes, they're outside of work, and therefore they have an independent existence.
What if they're injured on the way to work? Are they still external, or are they intermediate?
Yes, I think that would still be external because it's not in the normal course of the air carrier's operations. I mean, they could, on the way to work, for instance, be interrupted by some sort of terrorist attack or some other event which prevents them getting to work. It would still be the same point that they're not able to attend work. So you've got the underlying problem is crew absence. That's what's occurred. And that's put the normal operating system that's, in a sense, that is
But it becomes important for you whether the illness is contracted while at work or before getting to work?
Not necessarily, because it could do, because if the illness is contracted at work, then I think it'll be much more difficult for the carrier to satisfy the test, because it.
Well, then they'd no longer be a third party.
It'd no longer be a third party, and there would then also be the difficulty with control, potentially. But if it's something that is outside of work that happens, then it doesn't suffer the same problem. And what we are concerned to emphasise is that the analysis has to, consistent with what's been done in other cases, is actually, when you look at the inherency test, is to actually identify the source of the problem. There has to be a rational structure to analyse the source of the problem. And then one applies the analysis as to whether that source is itself a part of the air carrier's normal activities or not.
But when the pilot or the crew are in the overseas destination, they fly to wherever it is, they stay there overnight, and then they fly back to the UK. When they're staying overnight in the foreign location, are they at work or not at work?
They're not at work. It's their own time. They're free to act as they want, but they're also not treated as at work, and certainly that period of time is not counted as any sort of.
But they're under obligations not to drink too much alcohol in the period before, or to make sure that they're fit to attend work.
Certainly, there will be obligations that extend beyond work.
So there's control over them.
Well,
there are rules, aren't there? There are very strict rules about drinking and resting and fitness.
If there are, so if the source is, for instance, inebriation at work, then that would be a different analysis. So there would be rules that go to that extent. So
there are rules about what they do in their time at the foreign location when you say they're not at work, in order to ensure that when they show up for work at the appointed time, they're not inebriated, fit, properly rested.
There are certainly professional obligations, and there are rules that require them to.
Conduct rules that the carrier exercises over them as their employees.
There are, and certainly if there was a cause or a source that fell within that, then one could see that would not satisfy the inherency test. But equally, if there's a cause that falls outside of that, then it would be a third-party act. So, for instance, if there's a directive that says that a crew member is not able to fly for whatever reason by an authority, then that would be external. And even though there is crew absence on the day, one is still looking at the cause of that, or the source of that, and analysing whether that source is inherent to the normal operations of the air carrier. And there would certainly not be the question of any actual control over that. And obviously there'll be cases where it may not be quite so clear-cut, but in this case where there is unfit for work, and there's no suggestion of it engaging any of the air carrier's rules for behaviour when off duty. That is an external event and equivalent to a third-party event in our submission, and would engage the inherency requirement or non-inherency requirement, because that's not part of the air carrier's normal activities, nor would it satisfy the control. There would then be a different debate to be had, an inquiry as to whether, notwithstanding that absence, the carrier should still have been able to operate that flight through the all reasonable measures requirement. So then you get into question as to, well, how often does something like this occur? And what contingencies have you built in? Do you have spare crew available? If not, why not? And so forth. But that all goes to the all reasonable measures approach. And what would be an erroneous approach, and what was the approach taken by the Court of Appeal, was to try and blur the fact that you do have staff absences occurring. It is something that's foreseeable or frequent, and that the response to that somehow informs whether it's inherent or not. But as we saw from the Wallentine-Herman decision, that's not the correct approach to be taken.
When you're trying to get a replacement pilot, does the airline then take into account why the staff member has not turned up? So do they say, oh, well, this pilot, he was knocked down by a car, that can't possibly be considered anything other than an external event, so we're not going to get in a replacement pilot, we're just going to cancel the flight. But if he had some problem which was clearly caused during the flight or arose because he fell down the steps of the aircraft or something, that is intrinsic, so we will get a replacement pilot. I don't understand how you're saying is the reasonable measures only necessary if it's...
No, the reasonable measures, I mean, an airline, the reasonable measures arises where you have a delay or a cancellation. The airline's going to do that in any event because it has its planning contingencies in place. The question is whether that is sufficient to allow it to say that all reasonable measures have been exercised, notwithstanding this extraordinary circumstance. So in the example that my ladyship has given, it wouldn't arise in practice because there is already contingency planning in place. And so if for whatever reason staff is not absent, whether it's something that is inherent to the carrier or external, it will still have to then deal with how it's going to react to that, and that reaction will be part of its ordinary planning and contingencies in place.
Doesn't that demonstrate that that's part of its ordinary operations to have contingency plans? It's an inherent part of its operations that crew will become ill, and therefore it has to control that by putting in place measures to plan and...
Yes, but that becomes part of the all reasonable measures requirement.
Why? Isn't it part of the inherency and control?
Well, because the inherency and control is looking at the underlying cause, the underlying source of why the pilot is not available.
So when the pilot got gastroenteritis or whatever it is, when as Lord Justice Coulson put it, when he ate the prawn sandwich, is that what you're saying?
Well, I mean, in this case, that was his example as opposed to what happened in this case. In this case, the pilot felt unwell, declared himself unfit. But if that is still what you analyse as to whether or not that is the external event. One can look at the reasonable measures and requirement in any other example. I mean, if you take the bird strike. You have an aircraft that's not available for flight. That's the basic problem, is the aircraft is not available for flight. That is part of the normal operations. The aircraft has suffered damage. They suffer damage through normal operations as well. They've still then got to make plans as to how they deal with that. Either they're going to bring in a replacement aircraft or get an engineer to look at it. But in that case, because the damage has been caused by a bird strike, the act causing the damage is what's looked at for the inherency limb. And as that case illustrates, the air carrier could rely on that only so far when it came to delay that was caused by its own requirement for a second engineer. That failed to satisfy the reasonable measures requirement. I mean, in all these cases, one can be reductive and one can say it all relates to the operating system, because the business needs an aircraft and needs someone to fly it and someone to crew it. And if any of those aren't available, then you could say it's part of its normal operations, but that wouldn't be the way applying the way the case law has developed, which is you actually look at the source that has caused the aircraft not being available, or you look at the source as to why the other eventuality has occurred, and you analyse that to see if that's inherent and subject to control. And once you've carried out that analysis, if you've satisfied the extraordinary circumstances, you then say, well, what reasonable measures were taken to mitigate against this? That's how it works.
Well, how deep do you have to go in investigating the cause behind the proximate cause?
Not very deep, because all these cases are dealt with at the small claims court. The airline will, and as happened in this case, produce a contemporaneous flight record, effectively, of a crew log or a operations log, which will say this was cancelled for this reason. And that will either pass the test or not as just a matter of analysis. What you don't have to do is sort of say you're proving some sort of personal injury type claim where you need experts.
What does the call log say? What does the log say about the nature of the illness?
So in this case, it said that the captain was unwell, reported unwell, was investigated and was held to be unfit to fly. That's as far as it went, and that is usually what one would expect, all that would be presented. If that's not sufficient to satisfy the threshold, then the airline will fail the test. But in this case, that was held to be sufficient, both at first instance and on appeal. But there wasn't extensive disclosure, expert evidence that was carrying out intricate questions of causation.
But that doesn't seem to be enough to draw the distinction which I think you're accepting needs to be drawn between unfitness that arises during work time and unfitness that arises outside work time and is regarded as external or happens at a point where the pilot is still a third party rather than a member of the crew.
I mean, I think in this case it did, because it was a third party because it happened when he was in his own time and
But you would need to go behind the report, because to say the captain's reporting unwell tells you nothing about when he was reporting as being unwell. It could have been he was half an hour after arriving at work.
No, I mean, the contemporaneous record shows that he reported unwell before having to go to work. I mean,
but on your submissions, one would have to go into that analysis.
You would certainly need to know the timing, whether it's off duty or on duty, but you wouldn't need any detailed investigation as to causation. I mean, it's no different from a technical problem case where, again, the airline has to reduce the evidence as to the source of the technical problem.
But the difference here is that you're dealing with sensitive personal data of the pilot.
Sorry.
And the pilot may have reported unwell because just discovered just had some terrible diagnosis, which he probably prefer that his colleagues don't know about. So how do you deal with that kind of issue?
Well, again, I think it would be dealt with in the same way as in this case. It would be at a very high level that the captain reported unwell before reporting for duty.
So you say what you would be looking at is whether he reported as unwell before or after he arrived for his shift? Or
Yes. There is one other case, and I'm conscious of the time, which is a post-exit day or IPCD day decision of the...
This is the Portuguese one.
This is the Portuguese one,
yes.
Which again is against me if it applies. And since you have a discretion, I would invite you not to follow it. And the reason for doing so is it fails in my submission to follow the case law that the EU has previously followed and that is been regularly applied. So that is the TAP case, and that's at page 913. And again, this was a case where there was unexpected absence due to illness or death, and effectively there was a sudden death of one member of crew, and the remaining crew didn't want to fly because of the reaction to that.
Yes.
The facts are page 915, paragraphs 7 to 8. The synopsis of the question that the court had to consider is then at paragraph 15 at page 916. And then at paragraphs 20 to 23 is the approach that court took to inherency. And so they start off by determining whether the unexpected absence due to illness is essential, is capable of constituting by its nature an event which is not inherent. And then it deals with, at a general level, at paragraph 21, that measures relating to the staff of an operating air carrier fall to be within the normal exercise of air carrier's activity. And therefore, as a matter of course, the carrier may be faced with unexpected absence due to illness or death. According to the management of such an absence remains intrinsically linked to the question of crew planning. And then 23, the absence is due to unexpected death of a member of staff whose presence is essential to the operation of the flight, which occurred shortly before departure of the flight. Such a situation, however tragic, is no different from that which a flight cannot be operated because a member of staff has unexpectedly fallen ill shortly before it. Thus, it's the very absence due to illness or death of one or more crew members, even if it was unexpected, and not the specific medical cause of that absence, that constitutes an event inherent to the normal exercise of the carrier's activity. And we say that's incorrect reasoning because it's not the event itself that one has to look at, but you have to look at the source. Otherwise, if you go back to Wallentine and Herman, it would simply have ended, the analysis would have ended with the very absence of a serviceable aircraft for operation, or even in Peskova, the absence of an aircraft for operation. One has to go back to the source of that to then identify whether or not that occurs. I mean, on this analysis, even if the illness or death was due to some terrorist activity or something completely horrific, it would still, on this analysis, be said to be inherent to the air carrier's operation. And that can't be right, and that's not right according to previous authority, because otherwise it's bringing the analysis back to just the simple unavailability of your infrastructure for your operations. But it always requires you to go and look at the source of that, and then you analyse that. My lords and ladies, you've been very kind and indulgent, so I've probably used all my time, but
I'm afraid you have used up all your reply time. Of course, we've not been kind or indulgent at all, because we've been quizzing you pretty intensely on the first issue. But there we are. Thank you, Mr. Shah. We're very grateful. Mr. Rawlinson will resume at 2 o'clock, and the timetable will run 20 minutes behind the published timetable, but we'll still start at 2 o'clock.
Well, my lord, in the light of what's fallen from the bench this morning, it may well be that actually I can still finish on time, because, of course, what always falls helps to concentrate minds, and there are certain matters I can truncate.
Very well. Thank you. We'll rise now. We'll sit again at 2 o'clock, please. Thank you.